If a bank is trying to auction off your property under the Sarfazi Act, wait. Before you panic, check the date on their valuation report. Did you know that thousands of bank auctions are completely illegal, consistently because the bank is using a stale, outdated valuation? In this video, I'm going to reveal the exact legal loophole, backed by the Supreme Court, that can completely crush an invalid sale notice. If the bank got your property valued years ago and is still using that exact same price to sell it today, they are violating the law. Let's break down exactly how you can catch them and stop the auction. Here is how banks cut corners. When a borrower defaults, the bank takes possession under Sarfazi. According to Rule 8.5 of the Security Interest Rules, the bank's authorized officer must get a valuation from an approved valuer before setting the reserve price. But what happens if the first auction fails and the second one fails? Months or even years pass by. Instead of getting a new valuation, the bank mechanically copies and pastes the old price into a fresh sale notice. This is where they break the law. Real estate prices change. If the bank uses a valuation report from a year ago, they are completely ignoring market appreciation. They aren't trying to get the best price for your property. They are just trying to liquidate it fast to recover their own loan amount. And legally, that is a massive procedural irregularity. If you want to fight this in the Debts Recovery Tribunal, DRT, you need heavy ammunition. Here are the 3 cases you must cite to your lawyer. First, the Supreme Court landmark. In the case of M.R. Vasumathi versus Indian Bank, the Supreme Court made it clear that the ultimate goal of a Sarfazi sale is fair, transparent realization. If an auction fails, the bank cannot blindly rush into a new one. They must obtain a fresh valuation report from a government impaneled valuer to protect the asset from being undervalued. Second, DRAT Allahabad. In a major appellate tribunal ruling, an entire auction sale was completely thrown out. Why? Because the bank used a stale valuation report from months prior. The tribunal ruled that satisfying timelines doesn't matter if you violate the core foundation of Rule 8.5. So, how do you use this to save your property? Here is your 3-step action plan. Demand the valuation report. Under Sarfazi, you have the right to know how the bank arrived at the reserve price. Check the date on that report immediately. Hire your own valuer. Go to a government-approved valuer and get a current, independent valuation of your property. If your report shows the property is worth significantly more than the bank's old reserve price, you have concrete proof of undervaluation. File under Section 17, take both reports to the DRT, and file a securitization application. Argue that the bank breached its fiduciary duty to maximize asset value under Section 13.7. Banks count on the fact that borrowers don't know the strict rules of the Sarfazi Act. Don't let them undervalue your hard-earned property. If you found this video helpful, hit that subscribe button, leave a comment if you're currently dealing with a sale notice, and share this with anyone fighting a recovery case. Knowledge is your best defense. See you in the next video.